Welcome back to the Deep Dive. Today we are opening a file that feels less like a dusty legal case and more like a noir thriller written by a logic professor.
It's a great setup.
We're talking about a mathematician, a bank vault, and this very specific blurry moment in time where a bad idea becomes a permanent criminal record. The case is People v. Staples.
It really is a cinematic setup, you know? You have the blueprints, the acetylene tanks, the calculated risk. But the drama here isn't about some high-speed chase. It's about a heist that just stopped and the legal headache that it caused.
Right, and that's the hook. We are diving into the doctrine of criminal attempt. It sounds pretty straightforward. You try to do a crime, you fail, you get arrested. But as you look at the source material, especially Staples, you realize there is this massive gray area.
It's the foggy boundary between what we call mere preparation and actual perpetration.
So just picture our guy, Mr. Staples. He's a mathematician. He rents an office right above the bank. He brings in heavy drills, blow torches, the whole 9 yards.
All the gear.
He actually bores holes in the floor. But then, nothing. Silence. He stops. He never breaks through to the vault. He just packs it all up.
Right.
The question we have to answer today is, at what exact second did his plan transform from, preparation, which is legal, by the way, into a criminal attempt?
And that is arguably one of the most difficult lines to draw in criminal law. To figure this out, we have to analyze what's called the ambiguity of attempt under California Penal Code Section 664.
Okay.
We're going to map out the whole analytical path, the requirement of specific intent, the critical overt act, and this fascinating tug-of-war between two legal tests, the interruption theory versus the slight acts rule.
All right, let's get our bearings before we get to the drilling.
Yeah.
As the inquisitor here, I need to understand the baseline. What is the fundamental black-letter definition of an attempt under the statute?
Okay, so the general rule comes from Penal Code Section 664. To convict someone for a criminal attempt, the prosecution has to prove two very distinct elements.
Two things.
Two things. Element one is specific intent. You must have the specific intent to commit the actual crime, in this case, burglary. You can't just be reckless. You have to want the result.
Okay, so that's the mental state. What's element number two?
Element two is a direct, ineffectual act. This act has to be done toward the commission of the crime, and this is the key phrase. It must go beyond mere preparation.
That phrase, mere preparation, feels like it's doing a lot of heavy lifting. I want to drill down on that overt act requirement. In our sources, there's this whole controversy about interruption. What is the defense theory here?
This is where it gets really nuanced. The defense will often point to a case called People v. Buffum, and the theory there is that for an act to be an attempt, it has to be in such progress that it would be finished unless it was interrupted by circumstances independent of the person's own will.
Meaning, if I stop because I get cold feet or my conscience suddenly kicks in, Buffum suggests I haven't actually attempted the crime because the interruption came from inside my own head, not from the police kicking down the door.
That is the argument, exactly. If you stop yourself, you haven't really attempted it, at least in the eyes of that specific test. You still had control.
That seems, very generous to the would-be criminal. What's the counter-argument? What test does the prosecution prefer?
So the prosecution, they look to a different case, People v. Anderson. And this creates what we call the slight acts rule.
Okay.
The rule says that whenever the design, and by design we mean the intent of a person to commit a crime is clearly shown, then only slight acts and furtherance of that design are needed to constitute an attempt.
Slight acts. Wow, that sounds like a much, much lower bar.
It is much lower. The logic is, if we know for a fact you intend to rob the bank, maybe you confessed, you wrote a detailed plan, we don't need to wait for you to start cracking the safe. A slight act towards that goal is enough to, trigger the arrest.
Okay, I see the conflict. One rule says, wait until they literally can't turn back. The other one says, nip it in the bud. To help us visualize this, the court in Staples talks about two categories of attempts. Can you give us some visceral examples of these?
Yeah, the court breaks this down really well. Category one is what we call the complete but failed attempt.
Give me the movie scene version of that.
All right, picture this. It comes from People v. Van Buskirk. An actor takes aim at a victim, stares them right in the eyes, and pulls the trigger. But click,
Nothing.
the firing mechanism jams.
Terrifying, but clearly an attempt. No question.
Right. Or take People v. Grant. Someone plants a homemade bomb on an airplane. The timer ticks down, the fuse burns, but the bomb just sputters. It fails to explode.
So in those cases, the bad guy did everything they possibly could. It was just bad luck or bad engineering that stopped them.
Exactly. Analytically, these are clear-cut attempts because the actor performed all the acts necessary. It was just extraneous circumstances that caused the failure.
That makes perfect sense. But our mathematician, Staples, he didn't get that far. He didn't finish the job. So where does he fit in?
He falls squarely into Category 2, the interrupted process. This is where the actor has passed beyond preparation, but has not taken that very last step.
And the court references a real heavy hitter in legal theory here, right? Judge Learned Hand.
Yes, from a case called United States v. Kaplan, Learned Hand articulated this concept of passing the locus ponententii.
Locus ponententii. Can you translate that for us?
It means the place of repentance, or, maybe more dramatically, the point of no return.
The point of no return.
The Learned Hand doctrine basically says you don't have to do the last possible thing, you just have to go far enough that it's clear you're not turning back on your own.
And why does the law care? Why not just wait until the last second to be absolutely sure?
It's all about public policy. Society doesn't need to wait until the last proximate act to intervene. We don't need to wait for the bomb to go off or for the bullet to be flying through the air. The police need the authority to stop the actor once the plan is unequivocally in action.
That brings us squarely back to our mathematician. Let's analyze People v. Staples. We're going to break this down rigorously to see how these rules actually applied to him. First, what are the legally dispositive facts?
Okay, here's the summary. The defendant, Staples, was a mathematician. In October 1967, his wife went away on a trip, and while she was gone, he rented an office on the second floor of a building in Hollywood.
And crucially.
Crucially, this office was directly above the mezzanine of a bank vault.
I'm guessing he didn't rent it to grade papers.
Definitely not. He rented it under an assumed name. During the pre-rental period, he brought in a ton of equipment. Drilling tools, 2 big acetylene gas tanks, a blowtorch, and a linoleum rug, probably to muffle the sound.
Wow.
He even quizzed the building custodian to find out the building was totally empty on Saturdays.
So he was doing his homework. What happened when Saturday, October 14th, rolled around?
Staples went to work. He drilled 2 separate groups of holes into the floor of the office, aiming specifically for the vault below. But, and this is the whole twist, he stopped drilling before the holes went all the way through.
Why? Did he hear a siren? Did his drill break? What happened?
Nothing like that. According to his own confession, he stopped because he was tired, he was scared, and he had a realization. He wrote that the actual commencement of his plan made him realize that a fugitive life was way less enjoyable than his life as a mathematician.
A sudden burst of clarity. Logic finally prevailed.
It did. He left. But the landlord eventually found the tools and the holes in the floor, called the police, and Staples was arrested. He then confessed to absolutely everything.
So, knowing all those facts, what was the core legal issue facing the court?
The issue is this. Did the defendant's actions, specifically the drilling of those holes, go beyond mere preparation and actually constitute a criminal attempt? Or was the conviction invalid because he voluntarily abandoned the plan before being interrupted by any outside circumstances?
The whole defense is betting the house on that abandonment argument. Hey, I stopped, so I shouldn't be punished. Now, strictly speaking, what rule of law did the court apply? Please state the full black-letter rule and break it down for us into its testable element.
Okay. The court applied the rule for attempted burglary under PC Section 664. And this rule has 2 primary elements. Element 1 is specific intent to commit the burglary.
Right.
Element 2 is an overt act that functions as a direct, unequivocal step toward the commission of the crime specifically, an act that goes beyond preparation. And there is a vital doctrinal caveat attached to this rule.
Which is?
Once those 2 elements are met, abandonment is not a defense.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, specific intent?
Okay, so a mini IRAC on intent. The sub-issue here is pretty simple. Was the felonious intent clearly established? Did he really mean to do it?
And the application.
The application focused almost entirely on the defendant's own words. Staples' written confession was absolutely damning. He admitted explicitly that he rented the office to burglarize the bank. He admitted bringing in the tools and starting to drill for that specific purpose. He even described having a psychological commitment to the whole concept.
Wow.
So the conclusion on this element was, yeah, specific intent was clearly established. There was no ambiguity at all about why he was there.
Understood. That confession made the intent piece a complete slam dunk. Now, what about the second element? The overt act beyond preparation. This feels like the harder part.
It is. So here's the mini IRAC on the overt act. The sub-issue was whether drilling the holes was mere preparation, like, say, just buying the tools, or was it the actual commencement of the crime itself?
Okay, and what's the rule for that?
The sub-rule the court used is that the act needs to be a fragment of the substantive crime. It doesn't need to be the last act, like actually getting into the vault, but it has to be the start of the crime itself.
A fragment of the crime. I like that.
In the application, the court found that the drilling was the beginning of the breaking element of burglary. It was an unequivocal step, and they noted that the defendant himself called it the actual commencement of my plan.
He used those words.
He used those exact words. Therefore, the conclusion was that the acts went far beyond preparation and constituted a valid attempt.
And after analyzing all the elements, what was the court's final conclusion regarding the conviction?
The court affirmed the conviction. And the synthesis here is really the critical takeaway. Even though Staples claimed he abandoned the plan voluntarily because of his conscience or his fear, the court held that once his acts reached the stage of an attempt, which happened the moment he started drilling those holes, no subsequent abandonment can get you off the hook. The crime of attempt was already complete.
That is just fascinating. So the second that drill bit touched the floor, he was guilty, even if he packed up 5 minutes later and went home to do calculus.
Exactly. The equation, if you want to call it that, was solved the moment he made that overt act.
This is a lot to take in, especially that idea that you just can't undo your mistake. For our listener who might be trying to, synthesize this for an exam or just understand the law better, how do we operationalize this?
Okay, let's turn this into an exam framework synthesis.
Yeah.
If you are looking at a fact pattern like this, here is your diagnostic checklist.
All right.
Number 1, check specific intent. Is the design to commit the crime clearly shown? You're going to look for confessions, detailed plans, that kind of thing. If the intent is crystal clear, the court is way more likely to find an attempt.
Okay, what's number 2?
Number 2, apply the slight acts test. If that intent is clear, you don't need some massive action. Look for slight acts that move the plan forward.
Number 3.
Preparation versus perpetration. You have to ask yourself, has the actor performed an unequivocal act that is a fragment of the crime? In a burglary, is it the start of a break-in? In a murder case, is it pulling out the weapon? It doesn't have to be the final step.
And what's the last one?
And number 4, the abandonment trap. This is the big one. Did the actor reach the attempt stage? If the answer is yes, just est AP. Any subsequent abandonment, even if it's totally voluntary, is irrelevant to guilt. The crime is already committed.
The abandonment trap. That's a great way to put it. You literally can't unring the bell.
You really can't.
It brings us to a really provocative thought to end on. We have a mathematician here who, for all intents and purposes, calculated the odds. He realized the fugitive life wasn't a good outcome for him. He made a rational choice to stop.
He did.
But the law, it operates on a completely different kind of logic. The law says that once you drill that first hole, the equation is already solved against you.
Yeah.
You don't get any credit for doing the right thing after you've already started doing the wrong thing.
That's the lesson. The law protects society by drawing that line a lot earlier than we might intuitively think. Once you start the breaking, you've already broken the law.
And on that note, we'll close the file on People v. Staples. Thanks for listening to this deep dive.
Until next time.